It took 11 seconds for a title search to surface a defect that undid 4 months of paperwork my mother-in-law never let me see. That is the whole shape of this story, if you want it in a single sentence. But it starts 5 months before that Thursday, in a hospital room, 3 hours after I had my daughter, when my husband said yes on my behalf to something I was not awake to refuse. Let me back up. I have spent 11 years reading other people's deeds for a living, legal descriptions, chains of title, lien histories, recorded easements, notary acknowledgments, the quiet paperwork that decides, permanently and often invisibly, who actually owns what. Most people cannot tell you what their own title report says. I can usually tell you what's wrong with a stranger's in about 4 minutes. It is a precise field, and I am good at it, and none of that precision occurred to me to point at my own house until it was almost too late to matter. My name is Marissa Breck. I am 37 years old. My mother-in-law, Lorraine Hecht, learned what I do on the day Owen introduced us. She asked me one question about the job. What exactly does a settlement agent do? And, when I finished explaining, she said, "How useful." She meant it as a compliment, I believe. She had this precise way of categorizing people that felt like appreciation, but functioned more like filing. I was useful. Owen was accomplished. Bev was determined. Carl Oben, the estate attorney, was reliable. Every person in Lorraine's life had a drawer, and she maintained a clear sense of what went in each one. The difficulty is that she also maintained a clear sense of which drawers she controlled. Welcome back to our channel. This is the space for stories told by the quiet ones, the people who prepare, document their findings, and wait for exactly the right moment. If patient justice is your kind of story, you are in exactly the right place. Drop a comment and tell me where you are listening from, and hit subscribe so the next one finds you. Now let me tell you this one from the beginning. I bought the house at 22 Ridgewood Drive in the spring of 2016. I was 27 years old and had been working in title settlement for 6 years, which meant I had already sat on the other side of hundreds of closing tables and understood the weight of a signed instrument in a way that made buying my own home feel both ordinary and profound at the same time. It was my purchase alone, my savings, my name on the loan application, 8 years of renting and choosing the smaller option, and passing on things I could have afforded, because the bigger thing was the front door. The down payment came from all of that combined with one act of extraordinary grace. My maternal grandmother, Ida Varner, co-signed my mortgage because my credit history was 6 months shorter than the bank's minimum threshold. She was 81. She drove 90 minutes in her good coat. She sat at that closing table and reviewed every page of every document with the focused attention of someone who had spent a career taking paperwork seriously in a time when that was considered unusual for women to do. She signed her name in the 3rd paragraph of the deed, in the curved and careful handwriting of someone who had all the time in the world to be precise. She died in January of the following year. I kept the original deed. I keep it in a fireproof box in my bedroom closet, which is a professional habit from 11 years in a business, where the cost of a missing document is sometimes a house. Ida Varner's signature is in it, and I have looked at that signature more times than I can count, not only out of sentiment, but because of what it represents. She signed a legal instrument, at a closing table she would never sit at again, for a property she would never live in, because her granddaughter needed a front door that belonged to her, and there was no other way to get there at that exact moment. I have not forgotten what that signature means for a single day since she died. Owen moved in when we married 2 years later. He is a project manager at a commercial builder, the kind of person who is genuinely good at managing complex moving parts once all the relevant people have agreed on the goal. He is reliable inside a system that has already been defined. He trusted the people in his life to have done the work they were responsible for, and in most areas of his life, that trust had been validated, which meant the habit ran deep. He was not a document person. He had never needed to be. The house was in my name, and had been before he arrived. He knew this. He treated it as ours, which I always found to be one of the more decent things about him. He had never once suggested it should be otherwise. There is a year from early in our marriage that I keep returning to when I think about how we got here. The year I was offered a supervisor position at our firm. The process was straightforward on the professional side. I had the experience, the track record, the recommendation. What was less straightforward was the conversation Lorraine had with Owen about it on the Sunday she came for dinner while I was still at the office finishing a file. I did not learn the content of that conversation directly. I learned it the way you often learn important information in families like this one. Secondhand, a day late, already finished. Owen mentioned it the next morning over coffee, casually, the way he mentioned things that had already settled into a decision. He said his mother thought the new position would make the schedule complicated, especially if we ever wanted children, and that she had heard it could be a high-stress environment. He said he had told her he thought it was my call, which he meant as a compliment, and which I received as what it actually was. Evidence that the conversation had happened without me, that it had involved my professional life, and that he had been expected to weigh in on my behalf. I took the position. I did not raise it again, but I filed it away, which is a professional habit, and I have referred back to it since. I want to be clear about something, because the story I am telling is not simple, and I want to tell it honestly. Lorraine was not cruel to me. She was not cruel in any of the ways that would have been easy to name and easy to point at. She was kind at the right moments in the right ways. She sent birthday flowers. She asked after my mother. She remembered the name of the colleague whose father had been ill. What she did was structural, not personal. She built an architecture and assumed I would live inside it the same way Owen did, because Owen always had, and because the architecture was designed so gradually and so comfortably that most people inside it never noticed where the walls were until they tried to move one. I noticed where the walls were. I noticed and told myself it was easier not to say so, and I was wrong about that, and in that wrongness, the LLC became possible. His mother is 64, a retired human resources director with excellent posture and a practiced sense of how things ought to be structured. She is not a dramatic person. She does not yell or cry or make scenes. She operates through arrangement. She makes calls. She schedules conversations. She asks questions that are not really questions. And she presents completed plans as though you had always been consulted and had always agreed. In 6 years of Sunday dinners and long holiday weekends, and one kitchen renovation, during which she stopped by 6 separate times to weigh in on tile options, she never once raised her voice at me. She raised her voice at situations. She raised her voice at outcomes that had not been properly managed. She managed the people, which is a softer instrument and works on different things. I had spent 6 years watching it work on Owen and telling myself it was not my place to say so. This is the error I spend the most time thinking about now. Owen's sister Bev is 43. She is louder than her mother, by design, I think. The two of them occupy slightly different registers, and together cover a wider range of the available conversational space. Bev attended our wedding in a cream dress that landed approximately 4 deliberate shades short of white, and gave a toast about how Owen had always deserved a strong partner. She did not include me in that sentence about the strong partner. She directed it at Owen, as though announcing a verdict. I have thought about that sentence at various dinner tables since. She is not a malicious person. She is simply very certain of her positions, and certainty moves quickly and does not always check what it runs over. The LLC conversation started with Bev and was completed by Lorraine, and the way it started and the way it was completed are both worth understanding. I was 32 weeks pregnant when Bev came to stay for a long weekend in September. On the second evening, after dinner, she mentioned that she had attended an estate planning seminar in August. Very informative, she said. Very current. Families in our financial position were increasingly using a particular structure, a family LLC. You transfer your real estate into the entity. You receive liability protection. You simplify estate administration. You create a clean chain of ownership that survives the death of any individual member. The tax benefits at transfer were significant. Lorraine had already spoken with their estate attorney, Carl Oben. He was drawing up the paperwork now. It was essentially ready. It made particular sense, Bev said. For a property like mine, real estate, with clear value sitting outside the family entity. I said, very clearly, that I would want to see any documents before I signed anything. I said it while looking at Owen across the table, specifically so he would register it as something I meant and not something that would dissolve the moment I left the room. He nodded. He said, absolutely, of course. Bev said naturally. That's exactly the right instinct. Exactly what she would expect from someone in my field. She said it with warmth, and I believed her. I should say that clearly. I believed her in that moment. She sounded like she meant it. 6 weeks later, at 38 weeks, I still had not seen any documents. Lorraine had mentioned the LLC twice more, once at a Sunday dinner in October, and once during a brief phone call about the nursery paint color. Both times I asked directly whether I would have a chance to review the documents before anything was finalized. Both times she said, of course, just as soon as Carl has everything properly formatted. I was 38 weeks pregnant, finishing my last 2 weeks of work before maternity leave, and preparing in every remaining hour for a first birth, and I believed that when people said yes, they meant yes. This is the error I identified later, when I had time to identify errors. When someone keeps saying yes to a review they keep not scheduling, the answer is not yes. There was one more moment before Lily arrived that I still think about. In late November, Lorraine came for dinner on a Thursday with a folder. She said Carl had put together a preliminary outline of the LLC structure for our review, and she set it on the table between the dinner plates. It was 12 pages. I said I would read it carefully and get back to her with questions. She said, Carl just needs to know you're comfortable with the general direction before he finalizes the specifics. Owen said it all looked very solid to him, which was not the same as me saying I had reviewed it, but Lorraine seemed to receive it as equivalent. I took the folder upstairs after dinner. I read the 12 pages. It was a general overview with no executed instruments, no recording details, no specific language about the grant or the transfer mechanism. It described a plan. It was not a plan. There was nothing in it to sign. I put it back in the folder and decided I would wait to see the actual instruments when they were ready. This was the third time I had tried to create an opportunity to review and received something else instead. I was 35 weeks pregnant, and I set the folder on the nightstand and went to sleep. My daughter Lily arrived on a Tuesday morning in the first week of March. She was startling and perfect, and entirely unlike anything I had been prepared for by any of the books, or the practical materials, or the conversations I had assembled in advance, which I suspect is true for everyone, and which everyone is told in advance, and no one adequately absorbs until it is happening to them. For 6 weeks, I thought about nothing except her and feeding schedules and the specific sound she made at 3 in the morning when she was almost but not quite asleep, the small effortful inhale and exhale of someone working very hard at something that should be effortless and hasn't become that yet. I thought about almost nothing else. This is important to say, because what happened next required that I not be thinking. I should also say plainly, I was happy, tired and stitched together and happy, in the mixed, disoriented way that is apparently the actual texture of the thing rather than the clean version everyone describes beforehand. Lily had Owen's forehead and, I noticed on the third day and told no one, my grandmother's hands, the same long fingers, the same set of the knuckle. I did not think about property transfers. I did not think about county records. I was further inside my own life than I had been in years, and that is not an excuse for what happened next. It is the accurate context for it, and I want the story to be whole. Owen took 3 weeks of paternity leave. He was present and engaged in a way that surprised me, which is honest if slightly unflattering to say. He made coffee and took the late-night shifts and held Lily through the afternoon stretches when I was still learning how to sleep in 20-minute intervals. Lorraine came and stayed for the second week. She cooked and organized and cleaned and held Lily for hours while I slept in the back bedroom. I was genuinely grateful for this. I want to be precise about that, because it matters. The gratitude was real, and it is exactly what made the next part possible. The quitclaim deed was signed on a Friday evening in the 5th week of Lily's life, while I was asleep. I know this because Owen told me the following morning over breakfast, in the tone of someone completing a routine administrative task he expected would be received the same way. He said Bev had come by with papers from Carl. He had reviewed them. Lorraine had been there to witness. The LLC thing was done. He said the deadline was Monday, and the timing was unfortunate, but it was all very standard, and Carl had confirmed everything was in order. He used the word straightforward. People use that word when they need a thing to be simpler than it is, because simple is the only version that doesn't require more explaining than they have the energy for. I said okay. I was holding Lily in the kitchen, and the sun was coming through the window at a particular angle that made everything feel very still, and I said okay, and thought about feeding times, and I did not ask to see the documents. I told myself I would look at them later. This is the sentence I return to most when I think about this story. I told myself I would look at them later. I went back to work in early May. Lily was 8 weeks old. I had a sitter 4 days a week, and I was surprised to discover how much I had missed the particular texture of a precise, solvable problem after months of nothing but imprecise, unsolvable ones. I processed 4 closings in my first week back, 6 the next. The rhythm came back quickly, the way professional rhythms do when the underlying competence never actually left. I am good at my job, and I was glad to be back at it, and the LLC did not cross my mind for 3 months. 3 months. There was a small test I ran on myself in July, though I did not call it that at the time. Lily was 4 months old, and at a Sunday dinner I mentioned, lightly, that I'd love to finally see the finished LLC paperwork now that things had settled down. Mostly out of professional curiosity, I said, since I hadn't had a chance to look at how Carl structured it. Lorraine said she'd have Carl send a set over. 3 weeks passed. Nothing arrived. I mentioned it once more, just as lightly, at the next Sunday dinner. She said she'd follow up. Nothing arrived a second time. I want to be honest about what that test told me, because I did notice it, even if I didn't act on it yet. A completed, properly executed legal instrument does not require 3 follow-up requests and 2 more months to produce a copy of itself. Only something that isn't ready to be looked at behaves that way. I filed this away too, the way I had filed away the conversation about my promotion, and I went back to work, and I waited for a reason, better than a hunch, to do something about it. The Thursday in August that changed everything was ordinary until it wasn't. I was processing a refinancing application for a property at 19 Ridgewood Drive, 1 block from my own house. When I ran the title search, the county records returned several adjacent filings in the same tract, including a nested LLC structure that required me to sort through subsidiary entity ownership before I could confirm clear title on the subject property. While I worked through the entity search, a professional reflex that has become entirely automatic after 11 years fired somewhere in the back of my mind. Not quite a thought yet, just a pull. The same pull that catches a wrong date on a notary block from 10 feet away before I have consciously read a single digit of it. I called the county recorder's office, gave them my own home address, and asked them to read me anything recorded against that property in the last 6 months. The clerk read me the summary. A quitclaim deed, recorded March 28th. Grantors: Marissa and Owen Breck. Grantee: Hecht Family LLC. This is a trained response. The professional face holds when a finding is significant, because the professional face is what lets you keep working until you have the complete picture. My colleagues were 3 feet away. The file I had been processing was still open on my screen. I opened a new tab, pulled up the county recorder's public portal, searched 22 Ridgewood Drive, and the deed was there in 11 seconds. I read it from the top. Property description, legal description, transfer language, grantor section, grantee section, Hecht Family LLC, a state limited liability company. Signature block. Owen's signature was dated March 28th. My signature had no date beside it at all. I continued to the notary acknowledgement, the section of an instrument where a licensed notary certifies they were personally present and witnessed the signers execute the document. The notary had printed their name, affixed their seal, and written a date. That date was March 27th. The signature the notary was certifying, Owen's, was dated March 28th. In 11 years of title work, I had encountered this exact defect 3 times before. In every case, the instrument was voidable. A notarization certifying an event on March 27th cannot be valid evidence of a signature dated March 28th. The notary was not present when that signature was made. What they stamped was paperwork purporting to witness something they never witnessed. Under state statute, the acknowledgement fails. Without a valid acknowledgement, the quitclaim deed is defective. The transfer it purports to make is voidable at the election of the injured party. The injured party was me. I had just identified myself as the injured party in a defective instrument affecting my own home, at my own desk, on an ordinary Thursday, 3 feet from a coworker eating a sandwich. I printed the deed. I searched the state LLC registry for Hecht Family LLC and pulled the operating agreement on file. Managing Member, Lorraine Hecht. The managing member holds full authority over business decisions, including the use, lease, or sale of LLC assets. Passive member, Owen Breck. I was not named anywhere in the document. The house at 22 Ridgewood Drive sat on the asset schedule as a Hecht Family LLC property, with an estimated current value of $590,000. Full management authority over it resided with Lorraine. If the transfer had been legally completed, that meant Lorraine had the legal standing to authorize a sale of my home without my signature on anything further. Here is the near promise and the far one, both true at once, both still unresolved at that desk. 5 days later, I would be sitting across a conference table from the man who drafted that instrument, watching him understand exactly what he had filed. 2 months after that, I would be standing at another table entirely, in front of 12 people who believed they already knew how the evening was going to go. Nobody at that firm, and no one in that family, saw any of it coming from quiet, reasonable Marissa. I was always the one who read the fine print and never made a scene about it. I put everything in my bag and drove home. That night I fed Lily and made dinner and said nothing. Owen talked about a project site issue and I responded appropriately, and Lily fell asleep on the couch between us, and I looked at her small face and thought about the fireproof box in the closet and what Ida Varner had signed at a closing table 9 years before this one. I said nothing because I was not ready. You do not speak before the documentation is complete. What those next weeks looked like on the inside is something I have turned over often since. I went to work and ran title searches, and reviewed instruments, and attended closings, and answered emails in the normal professional register. I came home and made dinner and bathed Lily and sat with Owen on the couch and went to bed. I said nothing. I kept the title report in a folder inside my work bag and reviewed it, sometimes at lunch, not because the findings needed reviewing again, they did not change, but because reading it kept the situation real while I kept everything else running normally around it. There is a specific kind of patience that comes not from indifference, but from caring precisely enough to wait. I would not call those weeks peaceful. They were deliberate. Every evening I came home, the house was still my house. I could picture Ida Varner's deed in its fireproof box whenever I needed to. I told myself, as many times as it took, that I would not speak until the documentation was complete. This is the discipline I know how to practice. I practiced it. I called Pam Dutton the next morning. Pam is my direct supervisor. She has been in title work for 23 years and carries the specific composure of someone who has delivered serious findings about legal instruments for a long time and learned to communicate them without alarming anyone who doesn't need alarming yet. I described the situation without using my own address. When I finished, she was quiet for a moment. Then she asked 2 questions. Had the deed already been filed with the county, and was my name on the instrument as a grantor? Yes to both. She said, "You know what you have." I said I did. She said, "Get the documentation together. Don't say anything to any of the parties until you're ready to resolve it. And call me when you are." I said I would. Over the following 3 weeks, I built a complete title report on 22 Ridgewood Drive. I documented the original 2016 purchase, the mortgage co-signature, the clear chain of title through our marriage. I documented the LLC's formation date and management structure. I cross-referenced the state notary statute and the specific language governing the physical presence requirement. I identified the precise date discrepancy and the case law establishing voidability for defective acknowledgments. I prepared a 2-page summary with statutory citations in the margins. The last line read, "The notary acknowledgment contained in the instrument, recorded March 28th, is facially defective under applicable state law, rendering the instrument voidable at the election of the injured grantor." I showed it to Pam. She read it twice, asked me to verify 1 citation, and said, "You're ready when you decide to be ready." During those same 3 weeks, I did one more piece of quiet research. One evening at dinner, I asked Owen, as casually as I could manage, whether we had copies of the LLC paperwork anywhere in the house. I said I'd been meaning to look at the operating agreement. He said he thought Lorraine kept the full set at her place. He said Carl had sent copies to her. He said he hadn't actually read the operating agreement himself, because Carl had told him it was standard and he'd taken that on faith, the way you do when someone has been your family's estate attorney for 12 years. He said this without any awareness of what he'd just confirmed. He had signed an instrument transferring our home and had never read the document that established who then controlled it. I said that made sense and asked him to pass the salt. I also made a decision that week that I had not fully made before. I was not going to let the first time Carl Oben heard about the defect be in front of an audience. Whatever else this was going to become, it was not going to become theater staged by someone other than me. I called Carl's office on a Tuesday and asked his assistant for 15 minutes sometime that week, told her it concerned the Ridgewood Drive instrument, and gave her nothing further. He called back himself within the hour, pleasant, unbothered, assuming I imagined that I wanted to ask a routine question about the LLC before the family presentation Lorraine had already scheduled for that Saturday. I told him I would rather discuss it in person, at his office, and he agreed without any particular concern in his voice, the voice of a man who had handled a great many family structures and did not yet know this one was different. I drove to his office on Wednesday afternoon, on my lunch hour, in the blazer I wear to closings. His office had the kind of conference table every closing table has, laminate finish to look like something better, a box of tissues no one has ever needed pushed to one corner, a pitcher of water no one pours. I sat down across from him the way I sit down across from strangers 4 times a week, and I opened the same envelope I had been carrying since August, and I placed the title report in front of him. He read the first page standing up, the way people read something they expect to be routine. By the second page, he had sat down. I watched him move through the statutory citations, then the case law, then the specific dates. Acknowledgement March 27th, signature March 28th. I watched a man who manages family asset structures for a living arrive, in real time, at the understanding that he had personally prepared and filed a defective instrument affecting a client's daughter-in-law's home, without anyone in that transaction, including him, catching it before it recorded. "Where did the notary get the date wrong?" he said finally. Not quite a question, more the sound of someone trying to locate the exact point of failure. "I don't know yet," I said. "I know what the record shows. The record is what matters." Intent doesn't cure a defective acknowledgement. He was quiet for a while, turning a pen over without opening it, the same gesture I would watch him make again 3 days later at a different table, in front of an audience, when the gesture would mean something different to everyone watching it. "I need to speak with Lorraine before Saturday," he said. "I assumed you would," I said. "I wanted you to have the chance to do that properly, in private, before anything else happened. That's why I'm here and not there." He nodded slowly. He did not thank me, exactly, but something in how he shook my hand at the door was different from how he'd shaken it the one other time we'd met. Before I left, he asked me one more question, the only personal one of the entire meeting. "Why come to me first? You could have let Saturday happen and let the room do what it was going to do." I told him the truth, which was that I did not actually want to hurt Lorraine, or him, or anyone else in that dining room who had nothing to do with any of it. I wanted my house back. Those are not the same objective, and I had learned a long time ago in this job that people who confuse the two usually end up with neither. He didn't say anything else. He walked me to the elevator himself, which his assistant later told Owen was not something he typically did. I drove back to the office and finished my afternoon closings and told no one what had happened at lunch. Pam asked me, the Thursday before the dinner, whether I was certain about the private meeting approach, whether some part of professional caution should have told me to let the corrective process run entirely through the office without ever setting foot in Carl's conference room myself. I told her I had thought about that too, and that I understood the risk. A defective instrument doesn't become less defective because I handled the notification with more grace than I technically owed anyone. But I also told her that I had spent 6 years in that family being underestimated as the quiet one who wouldn't make trouble, and I did not want the correction of a legal record to be the only thing anyone remembered about how I'd handled it. I wanted to have given Carl, and through him Lorraine, an actual chance to do the right thing quietly before I ever let the documentation speak for itself in front of an audience. Pam listened to all of that and said only, "That's not a professional consideration. That's a personal one. You're allowed to have both at once, as long as you know which is which." I have thought about that sentence more than almost anything else she has ever said to me. I do not know exactly what Carl told Lorraine in the 3 days between that Wednesday and the Saturday dinner. I know only what I observed afterward, and what Owen told me weeks later when he was finally willing to talk about that week from his side of it. That his mother had taken 2 phone calls from Carl that he wasn't present for, that she had seemed distracted at a Thursday errand, and that when he'd asked if everything was all right with the LLC paperwork, she had said, "It's being handled," in a tone he now recognizes, in hindsight, as the tone of someone choosing not to cancel something she probably should have canceled. I want to pause here for a moment. If you have ever handed someone the truth privately, on purpose, before it could be used to embarrass them in front of a room, and watched them choose to walk into that room anyway, you know a very specific kind of stillness. If that's familiar to you tonight, drop a comment and tell me where you're listening from. And if you want to know what it looks like when someone walks into a truth they were already warned about, stay right here. This is what the whole story has been building toward. Subscribe so you don't miss what comes after. Now, back to Saturday. Lorraine's dinner invitation had gone out weeks earlier, before any of this. A Saturday dinner at her house to walk the whole family through the LLC structure with Carl. She wanted everyone to understand the estate planning benefits. A formal presentation, very organized, printed materials, Carl there to answer questions. Owen's cousin Therese and her husband Phil would come. Bev and Gary would be there. 2 investor friends of Lorraine's, a couple named Holden and Vera Kraft, who held interests in one of Bev's rental properties. And, naturally, Owen and Marissa. I told Owen I was looking forward to it, 3 days before I sat across from Carl at his office. This was true at the time I said it. By Saturday, it was true for an entirely different reason. Lorraine's house is a 4-bedroom colonial where everything is precisely arranged and nothing is ever quite out of place. The dining room seats 14. That evening, the table was laid with the good china, a fall arrangement of dahlias and orange chrysanthemums, and a printed folder at every setting with the Hecht Family LLC logo on the cover. A clean design, done properly, the way everything Lorraine hosts is done properly. Carl was already there when Owen and I arrived, near the sideboard with his briefcase open, and something in the set of his shoulders was different than the one other time I had watched him work a room. He shook my hand and held it half a second longer than strictly necessary. "Mrs. Breck," he said, quiet enough that only I would hear the particular weight he put on it. Dinner came first, because Lorraine does not skip the parts of an evening that make her a good host, even the evening she has already been warned about. Roast, root vegetables, good bread, a bottle of wine better than the occasion technically required. Owen's cousin Therese talked about her kids. Bev made a joke about a tenant, and Gary laughed like it was new. The Kraft couple discussed a property they were considering. Lorraine moved the conversation from person to person the way an experienced host does, filling glasses, asking questions, and if you were not looking for it, you would never have noticed that she filled her own glass twice in the time it took everyone else to finish their first, or that she did not eat much of what she had made. I noticed. I have spent 11 years noticing small inconsistencies in people who believe they are presenting something seamless. Carl ate almost nothing. He answered when spoken to, and otherwise sat with the particular stillness of a man rehearsing something in his head he had already decided he was not going to say until the moment required it. Twice I caught him looking at Lorraine in a way that was not quite a question and not quite a warning, something closer to, "Are you sure?" And twice she did not look back at him at all, which I understood, by the second time, to be its own kind of answer. Carl began the formal presentation at 7:45. He did it efficiently. Entity structure, liability protection, estate administration advantages, tax treatment at transfer, management hierarchy, member rights, using a thin folder with labeled tabs, referencing each section by number, the practiced competence of a man who has done this many times for many families. But it was a different kind of competence than the one I'd watched 3 days earlier at his own conference table, where he had nothing rehearsed and everything to actually work through in real time. Tonight he already knew what was coming. Tonight was a performance laid carefully over the top of something he understood to be already broken, and I watched him give it anyway, because Lorraine had decided the dinner would proceed, and he had decided, evidently, that it was not his place to cancel his own client's evening for her. The Kraft couple asked about their interests in Bev's rental property. Therese asked about inheritance tax implications. Owen made notes on his folder cover, drawing boxes around figures, believing, because nothing in the room told him otherwise yet, that he was learning something important about his family's finances. Carl reached the asset schedule: Lorraine's condominium, Bev's rental property, its annual revenue, its insurance treatment. Then, 22 Ridgewood Drive, transferred into the entity in March of this year. Current appraised value, approximately $590,000. Under the operating agreement, the managing member retains full authority over all decisions regarding this asset, including its use, lease, and disposition. Owen wrote down $590 and drew a box around it. I said, "Carl, I have a question about the transfer instrument for that property." He did not look surprised. That was the detail that told me, more than anything else that evening, that the private meeting had done exactly what I needed it to do. He looked, instead, like a man arriving at a moment he had already rehearsed arriving at. "Go ahead, Mrs. Breck." "For the benefit of the table," I said, "since I don't think everyone here has seen it, the notary acknowledgement on that instrument is dated March 27th. The grantor's signature is dated March 28th. My signature has no date at all. Under state law, a notary cannot certify a signature that wasn't executed in their presence on the date of certification. The acknowledgement fails. The instrument is defective. The transfer is voidable." I did not open my bag this time. I did not need to. Carl already had his own copy of my title report, the one I had handed him 3 days earlier at his own conference table, sitting in the folder in front of him. He opened it now, not because he needed to read it again, but because a room needs to see a document to believe a sentence. "Carl already has this," Lorraine said. It was not a question. Her voice had the particular flatness of someone confirming something she had been hoping, against the evidence, might not be true. "Since Wednesday," I said. I looked at her, not unkindly. "I gave him 3 days to speak with you privately before I ever intended to say a word of this at a dinner table. That was never going to be my choice to make in front of guests. It was his and yours." The room went very quiet, in the specific way a room goes quiet when it understands, all at once, that it has walked into the middle of something that was already decided before it arrived. Owen set his pen down on the folder cover. He turned and looked at me, and he did not look angry. He looked like a man who had just understood the exact size of the gap between what he'd believed was happening this week and what had actually been happening, and who recognized precisely where in that gap he had been standing. It was the most honest expression I had seen on his face in a long time. "You knew," Lorraine said to Carl. "You've known since Wednesday, and you let me host this dinner. I told you Wednesday night there was a significant issue with the March instrument," Carl said. "I told you we should postpone until it was resolved. You told me the dinner was already planned." Lorraine did not answer that. Bev said something to Gary that I didn't try to hear. Therese had both hands flat on the table, the way people do when they need a surface to be solid. Phil had leaned back 2 inches, a small physical withdrawal. The Crafts were examining the dahlia centerpiece with sudden, focused interest in flowers. And Lorraine sat at the head of her own table, perfectly postured, looking at me with an expression I recognized from 6 years of dinners, the one she wears when a situation has not arranged itself the way she arranged for it to. Except this time, there was something else underneath it, something I had never once seen on her in 6 years, the visible understanding that she had been handed a private door out of this and had chosen the public one instead. Owen said, "Mom," 2 letters holding an entire compressed year of things he had not said yet. "You are embarrassing this family in front of guests," Lorraine said. "I embarrassed this family Wednesday night," Carl said quietly, "when I told you to cancel and you didn't." Owen said, "Mom," again, the same 2 letters, considerably heavier. I took out my phone and called Pam Dutton. She answered on the first ring. I put the call on speaker and set the phone beside the report. "Carl Oben has had the report since Wednesday. He may want you to confirm the findings for the room. Pam said, I'm here. The defect in the notary acknowledgement is confirmed. The instrument recorded March 28th is facially voidable under applicable state law. The property at 22 Ridgewood Drive has not been legally transferred from the grantor's individual ownership. Any corrective action will require new instruments, properly executed, and properly acknowledged before a notary who is physically present at the time of signature. She said it without inflection. Findings are stated when the findings speak for themselves. The defect is confirmed, Carl said to the table, to no one in particular, or possibly to all of them at once. I need to advise my client on corrective options going forward. He did not look at Lorraine when he said it. Owen said "Mom" one final time, and then did not speak to her again for the rest of the evening. I reached into my bag and set the second envelope on the table, the original 2016 deed, between the dahlias and the LLC folders, and the wine glasses and the good china. Ida Varner's signature sat in the third paragraph, curved and careful, the handwriting of someone who once had all the time in the world to be precise, at a closing table of her own. My grandmother sat at a table like this one, I said, except it was an actual closing table, and she drove 90 minutes to be at it, so that I could have a home. That is not going to change because someone drew up different paperwork at this one. Nobody spoke for a long time. From the guest room, from the small travel crib I had set up before dinner, Lily made a small sleeping sound, the soft exhale of someone who doesn't know where she is, and doesn't need to yet. I want to say one more thing about that evening before I move past it, because I have thought about it more than almost anything else in this whole story. Lorraine had a door. Carl opened it for her on Wednesday night, in private, with no one else in the room to see her walk through it. She looked at that door for 3 days and chose the dining room instead, because I think, in the end, she could not quite believe that a defect this small, one date, on one line, on one document, could actually undo a plan she had already decided was finished. She was wrong about that. Paperwork does not care how finished a plan feels. It only cares what the record says. The corrective documents were filed in November. Carl prepared the corrective quitclaim deed, canceling the March instrument. A new notary sat at the actual closing table this time, physically present for the actual signatures, in the actual order they occurred. The county recorder added a notation to the title record documenting the original instrument's defect. 22 Ridgewood Drive came off the Hecht Family LLC's asset schedule. These records are public and permanent. Any future title search on that property will return the full history, the 2016 deed, the defective March transfer, the corrective filing, in that order, forever. I know, because I am the kind of person who checks. The winter that followed was quiet in the way winters sometimes are, after something large has finally settled. We put up the tree in December, and Lily sat in her bouncer in front of it and watched the lights with the intense philosophical focus of a 9-month-old encountering something she doesn't yet have language for. Owen and I started cooking together on Sundays again, something we'd done early in the marriage and slowly stopped, and started again in December because we needed the hour and the activity and something simple to organize ourselves around. One evening in January, over soup, he asked what I had felt during the 3 weeks between finding the deed and the dinner. I thought about how to answer honestly and said I had felt very clear. That wasn't the answer he expected. He thought about it for a while and said he thought he had spent years confusing trust with not looking closely enough. I said I thought those were related but different things, and that I hadn't always been clear myself about which one I was extending to which people. He nodded and went back to the soup, and we ate at the kitchen table, and Lily made sounds from the next room that meant she was awake and ready for us to come get her. There is a conversation Owen and I had in late November, a few days after the corrective documents were filed, that I have not told anyone else about until now. He asked me, at the kitchen table, whether I had ever considered just letting the defect go unaddressed, whether some part of me had thought about simply asking Lorraine privately to fix it quietly. No dinner, no confrontation, no Pam Dutton on speakerphone. I told him the truth. Yes, I had considered it, for about a day, in August. And then I had thought about the 12 pages that weren't a plan, and the 3 requests that produced nothing, and the deadline that arrived while I was asleep, and I had concluded that quiet, private fixes are only available to people who were given quiet, private input in the first place. I had not been, so I was not going to manufacture a private ending for a public problem just to make the room more comfortable for people who had never once made the room comfortable for me. He sat with that for a long moment. Then he said, I don't think I understood, until this year, how much of my life ran on assuming rooms would be comfortable for me by default. I told him that was, in its own way, exactly the thing we were both learning. Owen had a conversation with his mother that I did not ask him to have. He told me about it after it happened, which is how I knew it had occurred without me present, which mattered. He told her the corrective filing was necessary. He told her that decisions about their household would not be made without my knowledge going forward. He said it to her directly. I received this as the shape of courage available to him in that particular moment, and I chose to let it be enough. We are still married. That sentence is true, and I am glad it's true, and it also holds more inside it than a sentence usually shows. We went to a counselor for 4 months, starting in December. We worked through the years-long pattern in which he received his mother's arrangements as weather, and I absorbed the outcomes as though I had no standing to object to any of it. We talked, plainly, about what a shared household actually requires from both people in it. We are better now, not without the mark of where we broke, but steadier along the place where it healed. That part of this story, at least, I can tell you has an ending, and it is a good one. The other relationship in this story does not have an ending yet, and I have stopped waiting for it to arrive on any particular schedule. Lorraine still comes to some Sunday dinners, though less often than before, and the ones she attends feel different, more careful on both sides, less certain of their own footing. She has not mentioned the LLC once since November, and I don't expect her to. She sent a Christmas card in December that said, under her usual signature, one additional line she has never written in 6 years of cards. I hope you know, I never meant for you to be hurt by any of it. I have read that line perhaps 30 times since December, and I still do not know exactly what to do with it. It is not an apology, not quite. It might be the closest thing to one she has available to her. I don't know if there is more coming after it, or if that sentence is the whole of what she has to offer, or if we will simply continue like this indefinitely, careful, distant, occasionally almost honest. I used to need things to resolve cleanly. 11 years of title work will do that to you. Every file eventually closes, one way or another, with a clean record at the end of it. This is not that kind of file. I am still learning how to sit with the ones that don't close. Bev sent me a text in December saying she hoped I understood the estate planning had come from a genuine desire to protect everyone. I wrote back that protecting someone requires knowing what belongs to them first. I sat with that draft for 2 days before I sent it. She did not reply. I don't know if she will eventually, or if that's simply where that particular account stays open, unresolved, the way some accounts do. Therese called me once, in January, unprompted, the first time she had ever called me directly about anything in 6 years of being family by marriage. She said she'd been thinking about that dinner a lot, and that watching it happen had made her go back and look, for the first time, at some paperwork of her own that a different relative had once asked her to sign quickly, at a low moment, without much explanation. She hadn't signed it, in the end. She said she wanted me to know that. I told her that was a good thing to have not signed, and that most people never get the version of the story where someone else's dinner table teaches them to ask a question in time. We have not become close, exactly. But she sends a card at the holidays now, and this year, for the first time, it had her own handwriting in it instead of a printed signature. I took the original deed out of the fireproof box in November, after the corrective instruments cleared. I sat at my own kitchen table, which is not a closing table, but has held enough closing table conversations over the years to function like one, and I looked at Ida Varner's signature for a long time. She signed 4 instruments of consequence in her life: her marriage certificate, a small business loan application in 1968 that didn't work out, her living will, and my mortgage. She never owned a piece of real estate outright. She drove 90 minutes in her good coat and signed a deed for a property she would never live in, and she died 4 months later without knowing exactly how any of it would turn out. I think about that a great deal now, that she signed it without knowing, the same way I sat across from Carl without knowing, the same way Lorraine sat at the head of her table without knowing. None of us ever really know how the record will read until it's finished being written. You can only control what you put into it while it's still yours to write. I had a small frame made, simple wood, the right size. The deed is inside it now, hanging on the wall of my home office, above the desk where I run title searches every morning, in a house at 22 Ridgewood Drive that belongs to me and no one else. Ida Varner's signature sits in my peripheral vision every time I sit down to work. 3rd paragraph, curved, careful. The handwriting of someone who once had all the time she needed at a table that mattered. I have sat at hundreds of closing tables in my career, on the professional side of the transaction, watching other people's lives change ownership one signature at a time. My grandmother sat at one for me in 2016 when it was the only thing that stood between me and a front door of my own. And in November, I sat at one more, an actual one, with an actual notary actually in the room, and watched the record get put back the way it was always supposed to read. Then I open my files and I go to work. If someone in your life has ever made a decision about something that belonged to you, this is for you. The documents do not lie, and the person who knows how to read them will eventually find their way home, even if not every other door in the story gets to close as cleanly. If this meant something to you tonight, share it with someone who needs to hear it. Drop a comment and tell me where you are listening from. And subscribe. I will see you in the next one.